Hello, and welcome to Sacramento State Debate Team's Public Debate. We do one of these public debates every semester, but this is our first one that we've done fully online on this Zoom platform. So thank you for joining us and watching this video. We wish you could have joined us in person. We've done one of these every semester for the past 7 or 8 years, and they're always a lot of fun. What we do is, rather than focus on a competitive debate about the year's debate topic, we choose a topic of interest to the larger community, and we present more of an informational but still competitive debate about that particular issue. The Sacramento State Debate Team competes in Lincoln Douglas debate. We travel to approximately 10 to 12 tournaments per year, including nationals. We have, for the past 4 or 5 years, been a nationally ranked debate team, and we are currently ranked in the top 10. We have an excellent group of debaters this year, so far winning several tournaments, which is a little bit unusual because, again, we're doing everything online. So as we adjust to our online environment, one of the activities that we're still able to do is debate. We are able to compete and join debate tournaments across the country by showing up into Zoom rooms all over the place. So we're very excited to have you join us here for this public debate, and we hope you enjoy it. Our topic for this debate is about the Supreme Court. So the exact topic that we'll be debating is, should the United States federal government expand the size of the United States Supreme Court by adding more justices? We'll have both an affirmative side and a negative side. On the affirmative side, we have Sean Cox Marcellin, we have Ariella Sotelo, and we have Mark Espinoza. On the negative side, they will oppose the expansion of the Supreme Court. We have Kimberly Christian, we have Aaron Hutchinson, and we have Christopher Douglas. So the debate will consist of 5-minute speeches from each debater. The first 4 speeches will be followed up by cross-examination time, where the other side can ask questions. And then the last 2 speeches will be our case summaries, our final rebuttals, where there won't be cross-examination. All right, so here we go. Thank you very much. And we will begin the debate with a speech of 5 minutes from Sean Cox Marcellin.
Hello, everyone, and welcome to the public forum debate presented by the Sacramento State Debate Team. I would like to begin by thanking our coaches and administration who have supported our team in these unprecedented times. The continued success of our program is enabled by their hard work and diligence. Today, we are discussing the issue of expanding the Supreme Court of the United States. There has been a fair amount of discussion recently about the Supreme Court, including calls to expand or even pack the court. As part of this ongoing discussion, we will be debating today's resolution. The United States federal government should expand the Supreme Court by adding more justices. We, Sean, Ariella, and Mark, affirm this resolution. The Supreme Court should be expanded. Currently, according to Amelia Thompson DeVoe at 538.com, faith in the Supreme Court is lower than it used to be, and the confirmation hearings to appoint new justices have been getting more and more partisan. We think the best way to resolve this is by increasing the court to 27 justices with an 18-year term limit. Why 27? According to Jacob Russell, an associate professor of law at Rutgers University, Americans of all political stripes should want to see the court expanded. We need a bigger court because the current institutional design is badly broken. The right size is 3 times its current size, or 27. Perhaps you have heard someone express doubts about this proposition. Perhaps that someone is you. Isn't, one might think, expanding the court a radical remaking of a bedrock institution? No. Russell continues, Supreme Court enlargement only seems radical because we have lost touch with the fundamentals of our living, breathing Constitution. The flawed debate over court packing is an opportunity to re-examine our idea of what a Supreme Court is, and in fixing it, we are letting it live up to its intended potential. We see 2 key advantages of expanding the court through the method we are forwarding today. The first of these is that an expansion to 27 justices will help our current backlogged court system. The previously cited Russell says that by hearing many more cases, a larger court and docket would be healthier, allowing a uniform national resolution of more disagreements between regional circuit courts. At 3 times its current size, the court's ratio of justices to filed appeals would be more in line with that of the circuits, thus resolving discrepancies between the caseloads of the circuit courts and the Supreme Court. The second advantage is depoliticization. We take inspiration here from the Supreme Courts of many resilient European democracies. This model has garnered favorable views from their citizens, and they are known for maintaining a nonpartisan approach in their cases because of, in part, having term limits on their Supreme Court justices. According to Benjamin Barrows, a professor and dean at University of Toledo School of Law, by combining an increase in the court's size with term limits, Democrats could simultaneously address the Republicans' perceived theft of the 2016 vacancy and de-escalate the fraught politics of Supreme Court appointments. Limited terms would encourage presidents to value experience over youth in selecting nominees, reducing the stakes of any given appointment from lifetime service to a limited term would disincentivize norm breaking. It may also end the never-ending cycle of increased politicization of the Supreme Court. Russell adds that this model is not unprecedented to the United States, as it shows success in our regional circuit courts. The larger size of the circuits, the more it reduces the influence of single swing voters like Justice Kennedy or before him, Justice Sandra Day O'Connor. Second, there is a variance in the panels which are randomly drawn. Even on a supposedly liberal circuit like the West Coast's Ninth Circuit, cases are sometimes heard and decided by panels composed of conservatives. The system promotes variety and prevents excessive entrenchment of, say, a 5-4 majority. In reviewing the affirmative case for expanding the court, we see that our advocacy would be a powerful and effective tool by expanding the court to 27 justices and instituting term limits. This modernization of one of our central governing institutions is key to its legitimacy and efficacy moving forward, since it would increase the number of cases heard in the Supreme Court, thereby reducing court clog while also depoliticizing the court. These changes are beneficial, and at the end of the day, if you agree that the world we present is better than the world today, then you're going to vote for the affirmative in this public debate. Thank you.
Thank you very much, Sean. Excellent job. We will now have a period of cross-examination for 2 minutes where debaters from the negative side can ask Sean some questions. Go ahead.
Hey, Sean. So with your plan, how do you think that having faster turnover with the Supreme Court will actually cause people to trust them more with our justices?
That's an excellent question, Kim, and thank you for asking. So essentially, we're not just creating faster turnover, we're creating a more stable system for turnover. Right now, since justices go towards retirement or their death, it's very unpredictable when they're going to be retiring. By creating a set system in stone, justices know that they will be on the court for 18 years, and people know that those justices and their decisions will be lasting lifetimes.
Thank you.
Would there be any kind of appeal process where they could try and go again through the court?
No, ultimately, the Supreme Court is the one highest court of the land. And obviously, individuals attempt to retool their cases to try to get them to pass the court, but one cannot simply appeal the Supreme Court to any other institution.
So they should probably make sure that their cases are pretty solid before they get there.
Absolutely.
What processes are you going to use to randomize it? Are you guys going to use a software? Is it going to be in some kind of random jumble? Is it going to be a chicken? What are we going to use?
I assume that some sort of sufficient randomization system, much like we use in the circuit courts, can be devised of and used by the Supreme Courts. as I said, that part of the system is modeled on what we're using in the circuit courts right now.
Would that be a government thing or would that be a privatized thing?
I'm unsure of how the circuit courts do it exactly, but I'm fairly certain that the courts handle it themselves.
All right, that's all the time for cross-examination. Thank you very much. So now we will have our negative case presented. Our first negative speaker is Kimberly Christian.
Hi, I would like to reiterate what the other team said. Thank you so much for giving us your time and attention. We value this opportunity. We value this opportunity to debate the topic of increasing Supreme Court justices. Beyond expanding our number of Supreme Court justices, the affirmative team is advocating for an extensive overhaul of our Supreme Court system. We argue that their plan is not viable, nor is it beneficial to Americans. We believe this for three main reasons. First, having multiple courts is unconstitutional. There needs to be one court that sees all cases. This is imperative in maintaining the court's legitimacy, per Associate Professor of Political Science, Queen's University of Charlotte. Article 3 of the Constitution establishes the federal judiciary. It states that the judicial power of the United States shall be vested in one Supreme Court. One Supreme Court means one court for all hearings. The AF's plan to divide up the Supreme Court justices destroys the Constitution's intent. Implementing their plan will delegitimize the Supreme Court, leaving it akin to a circuit court. It must retain its legitimacy. Per Cornell University, proposals have been made at various times for an reorganization of the court into sections or divisions. Many justices have spoken out against multiple courts. Chief Justice Hughes stated that the Constitution does not appear to authorize two or more Supreme Courts functioning in effect as separate courts. In the words of the late Justice Ruth Bader Ginsburg, 9 seems to be a good number. It's been that way for a long time. I think it is a bad idea when President Franklin Roosevelt tried to pack the court. Secondly, the Supreme Court does not suffer from court clog nor backlog. They are merely selective, not understaffed. Article 3 says that all justices must hear all cases. It would take even longer to come to a decision. As then Chief Justice Charles Evan Hughes put it in an influential letter that helped sink Franklin D. Roosevelt's 1937 scheme to add justices, there will be more judges to hear, more judges to confer, more judges to discuss, more judges to be convinced and to decide. Judges confer both in person and as a group, and by exchanging written drafts and comments. A single quibble of wording or other snag in communication between two of them can delay agreement until it's fixed. The chance of such a hitch rises with increased court justices. A 9-member court has the possibility of having 36 two-judge combinations that generate friction and misunderstanding. Having more judges only confounds the problem, making cases take longer, possibly creating court clog. Third, depoliticization is not easily accomplished in the current political landscape. It occurs in direct correlation to social divisions. Current views on topics such as immigration, reproductive rights, and economic structures are just a continuation of our divisional past. The court is simply a reflection of that concept. Although beholden to the Constitution, judges' personal biases weigh heavy on their decisions. Henry Olson of the Washington Post states, virtually all tyrannies insist that judicial power be subject to the will of the government because they know that tyrannical power ultimately rests on force, and that means killing, suppressing, or imprisoning their enemies. The court shall be subjective of the people, not the state. An arranged effort to dismantle the discourse in the court will either create vastly separate courts or courts that are beholden to the state's view of rule of law rather than the people's. The Supreme Court plays a very important role in our constitutional system of government. First, as the highest court in the land, it is the court of the last resort for those looking for justice. Secondly, due to the power of judicial review, it plays an essential role in ensuring that each branch of government recognizes the limits of its own power. Third, it protects civil rights and liberties by striking down laws that violate the Constitution. Finally, it sets appropriate limits on democratic government by ensuring that popular majorities cannot pass laws that harm and or take undue advantage of unpopular minorities. Now, at the end of this debate, if you believe that their plan is substandard, non-viable, or unconstitutional, you will vote against it, therefore voting for the negative. Remember, you're voting for their entire case, not just if we should be packing the Supreme Court. Thank you so much.
Thank you very much, Kim. So now we will have cross-examination. So members of the affirmative team can ask questions of the speaker. So is the affirmative ready?
Yeah, I'm ready.
Yeah, no, go ahead. Let's have some questions.
So Kim, my first question to you is, you mentioned one of your authors that you quote talks about the importance of the courts to listen to the people. Is this because we currently elect our Supreme Court justices directly?
No, that's not why.
Then how do we have Supreme Court justices appointed in the status quo?
How do we have them appointed? So it's kind of a complicated process. They have to first be nominated by the president, and then they have to go through a vetting process of both the House and the Senate.
Are those institutions organs of the state?
Are they organs of the state? I'd say they're organs of the federal government.
Thank you.
You're welcome.
Anybody
else?
Yes, Kim, thank you for your presentation. I have a question. So when was Justice Hughes a court justice?
In I think 1937.
Okay, so the climate of the Supreme Court would be at a such different place than it is back when he was a justice.
I mean, saying something like that is saying that the Constitution is out of date or our ideals as a nation. I say that I like to think that our Supreme Court is timeless, and that an opinion of the Supreme Court justice is just important today as it was then.
Supreme Court decisions like Dred Scott or Plessy versus Ferguson?
I'm sorry, what was your question?
You say that Supreme Court decisions are timeless as they were then as they are today.
Or opinions. Supreme Court justices, I think their power and their standing is just as important today. If their opinions have changed over time on rulings, that's not what I'm talking about. So.
All right, thank you. That's all the time we have for that cross-examination. Well done. And now we will hear from the second affirmative speaker, and that is Ariella.
Okay. Okay. So, hello, my name is Ariella, and I'm here to continue speaking about the affirmative plan that the United States federal government should increase the number of Supreme Court justices to 27 with an 18-year term limit for each judge. The negative team made some points where they talked about the idea that the Supreme Court cannot consist of more than one panel, the legitimacy of the court clog, and politicization. But here are some important things to know when you are taking our points into consideration. Let me remind you of our initial point that my partner, Sean, made. Our first contention is that we, the affirmative, plan to expand the court to 27 judges and 18-year terms, which will help our current court backlog. Our second contention of court packing is depoliticization. The neg says that the Supreme Court cannot consist of more than one panel. However, we say the court will remain one court, just with multiple panels. I'd like to remind the audience that in the Constitution, there is no special reason why the court is the size that it is. The ideal size of the court should further its institutional purpose. In fact, it did not even begin at 9 and is written in its way to allow us to make these decisions. The negatives argument interact with our points by claiming that there is no legitimacy issue, inferring that the that justice will not be served. The issue with their claim is that legitimacy of the Supreme Court justices will stay the same because they would go through the same process, and there is a current backlog. According to a factoid that I accessed from the supremecourt.gov, there are approximately 7,000 to 8,000 cases, and only about 80 cases are heard a year. This leaves thousands unheard and seeking justice for their cases. In addition, in order to be heard by the Supreme Court, these cases must all be of importance. We solve the issue by increasing the number of judges so that more of these cases are heard. The negative also claims that our plan adds to politicization of the court. We disagree because we implement term limits which assist in stopping reckless politicization, because politicization is inevitable in the status quo, because there is no consequence to decisions being made, which is worse for justice because within those term limits, they are thinking less consciously about their decisions. With the current climate that the Supreme Court is in with implementation of Justice Amy Coney Barrett, we are seeing increased politicization. Our plan to add justices over a long period of time, allowing both liberal and conservative administrations opportunities to add justices, which decentivizes highly partisan appointment clashes. Also, the institutional consequences of presidential and Senate elections are much smaller because of the term limits. Our larger court also helps with reducing the influence of swing voters. Therefore, the affirmative's plan of changing the status quo would in effect decrease politicization. We find that we outweigh the negatives contentions on our plan of having 27 justices and 18-year terms. Again, there is no special reason why the court is the size that it is currently. And because of the current backlog and increase of politicization of the courts, the status quo must change or otherwise stand in the way of justice. Thank you.
All right, great job, Ariella. Thank you very much. So now we will have 2 minutes of cross-examination where members of the negative team will ask Ariella some questions.
Thank you, Ariella. I have 2 questions for you. The first question is, assuming you want to expand the court because we have 7,000 cases, and I want to elaborate and confirm, well, if we only have 70 to 80 cases that are heard by the Supreme Court, maybe those other 7,000 cases can be heard like they already are in the lower court. Maybe they weren't valid enough to go to the upper court. Would you agree or disagree?
I would disagree because in order to get to the Supreme Court, you have to be of importance. So that does mean that they are heard by other courts, but they are still seeking justice. And I think that they're valid in terms of wanting to find that justice.
Okay. And the second question I have is on the term limit side. Shouldn't there be something to be said for retaining experienced justices on the term limits? Because we may have a great justice, say Ruth Ginsburg, for example, but she would have been gone after 18 years. We run the risk of not being able to retain that justice with all of that experience. Do you not think that that is important?
So with opinions on, so everyone has their opinions on the justices, and with that being said, we are not saying that anyone isn't doing an adequate job. What we're saying is that we're going to have a term limit so that we will make sure that there is equal opportunity for justices in order to serve, because the lifetime service that we're seeing is starting to create politicization where they value experience over youth.
Oh, thank you. Quick question. So being that, since Bush Jr., Clinton, Obama, Trump, everyone has appointed a Supreme Court justice, how is it that you think that assigning 2 will drastically change that, since presidents in recent history have all nominated and had them conferred?
Well, it will change by making sure that there will be no term limits. So they will value experience over youth. because it'll be a recycling. I mean, not recycling, because there will be a new implementation, so it'll be more progressive.
All
So
right,
you're
thank
saying
you.
that because
That's-
they're older that they, oh, sorry. Okay, I'm done.
We're out of time for cross-examination. Thank you. That was really exciting to watch. So now we will bring up our second negative speaker, Aaron Hutchinson.
First of all, thank you for your attendance today. The United States Constitution establishes a system of checks and balances to protect the American people from abuses of power by any one branch of the United States government. At the foundation of this system of checks and balances is an independent Supreme Court created to prevent the abuse of power by a president or Congress. Unfortunately, the intense partisanship in Washington, D.C. has brought out worrying proposals to increase the number of justices on the Supreme Court and then pack those new positions with political allies. The U.S. Constitution does not currently specify how many justices may serve on the Supreme Court, creating an opening that a future president and Congress may someday exploit for political advantage, which is being discussed or proposed today. That is why we, as a group, are leading a bipartisan effort to preserve the independence of the United States Supreme Court by asking Congress to support an amendment to the Constitution that simply states this: the Supreme Court of the United States shall be composed of 9 justices. This amendment would permanently prevent the president or Congress from manipulating the size of the Supreme Court to obtain a political advantage. Any attempt to pack the Supreme Court would set off a judicial arms race, which will further divide our country. If one party succeeds in packing the court, the next party to win a majority may move to the same direction in retaliation, further eroding respect for the court and the rule of law. Congress last modified the number of Supreme Court justices in 1869 when it raised the number of justices from 7 to 9. As we all know, Franklin D. Roosevelt, past president, famously tried to pack the Supreme Court in 1937. His effort failed because the American people, as they do today, want the Supreme Court to remain an independent branch of government. We only do that by maintaining the status quo of 9 justices. Both major presidential candidates have said in the past, right, they will oppose efforts to pack the court, but a constitutional amendment such as we are proposing is the best safeguard to protect the nation permanently from that risk. Congress has previously amended the Constitution to meet the challenges of the times by guaranteeing voting rights for women Americans over the age of 18, as well as an amendment limiting presidents of 2 terms. Our common sense amendment addresses the real concern today that partisans in either party would try to pack the court at the expense of all Americans. Leadership in Washington, D.C. are finding it harder and harder to find common ground. We hope the elected officials on both sides of the aisle will join this effort to preserve the integrity of our judicial system. The future of our nation depends on the preservation of our independent Supreme Court to protect our rights and freedoms. This is why America needs this amendment. I have 2 supporting cons to support this case too as well. The Supreme Court is largely balanced. Court packing would increase political interference in the independent branch of government. It's a slippery slope that would allow each president to add justices for any political reasons. Con 2, historical precedents must strongly support a 9-judge Supreme Court. While the U.S. Constitution does not specify the number of Supreme Court justices, neither does it specify that justices must have a law degree or have served as judges. Our latest appointment has heard little to no cases at the Supreme Court level or at the lower court level, and she was just pushed through. However, historical precedents have set basic job requirements for the position as well as solidified the number of justices. The Supreme Court has 9 justices consistently since 1868, when Ulysses S. Grant was president. Changing the number of justices has been linked to political conniving, whether the 1866 shrinkage to prevent Johnson's appointments or the 1801 removal of 1 seat by President John Adams to prevent incoming President Thomas Jefferson from filling a seat, or the 1937 attempt by Roosevelt to get the New Deal past the court. We should not break with over 150 years of historical precedents to play political games with the Supreme Court. And that's why today, audience, I ask, and judge, I ask you to rule in the favor of the negative.
Thank you, Aaron. Great job. So at this point, we will have our final section of cross-examination where members of the affirmative team will ask Aaron some questions. Ready, affirmative?
Yes, Aaron, thank you for your presentation. So you stated that there was politicization with the new justice that was currently implemented into the Supreme Court, but then you make an amendment that basically locks in the status quo. Aren't you saying there's an issue with the status quo?
No, actually, I'm not. We need to stay firm on the status quo of 9 justices. And the reason being, I believe that if we expand,
Aaron, you've become muted.
we're going to make it worse than it already is.
I'm sorry, I missed the last part of your answer.
We would make it worse than it already is if we expanded the Supreme Court justice. Politicization would increase if we did that.
So that would just happen with expanding the number, but not the term limits?
Can you reframe that question again?
So you're saying you're advocating for not expanding the court, but you didn't say that you are disagreeing with our terms, with the term of 18 years.
I'm actually disagreeing with the terms too as well, because again, we would be dumping the experience out the door. So Ruth Ginsburg, we wouldn't have had her as long as we did if we had an 18-year term limit. But
if you value Ruth Bader Ginsburg's opinion and they go through the same process that they did with the 9 Supreme Court justices, I don't understand where aren't as qualified as Ruth.
Well, we are assuming that every candidate that we push through is going to reach and be qualified.
Aren't we currently assuming that?
Okay, that is our time.
We are.
It always seems to get really heated at the end there. I really enjoy that. But that's the end of our cross-examination time. So to make this work on our debates, so if you're in my class, you may be wondering what happens next in terms of who's speaking, but we will have back-to-back negative speeches here because the affirmative, with the burden of proof, they'll speak both first and last. So our next speaker is also from the negative side to finish up and summarize the negatives case. We have Christopher Douglas.
Hi, I want to once again thank everyone for tuning in. I want to thank our coaches for really being there for us during this time with school, with life and everything. It's definitely an interesting event going into an online debate, but we definitely appreciate their support and everyone else who's supporting our team. To move on to the case, there are multiple holes that we've already discussed in the affirmatives case. One being the amount of judges, 27 judges from 9 judges. They're thinking that it's going to somehow solve politicization in the court system, when in fact it's going to do the opposite. It's going to create more issues. It's going to create more dissent between them, because essentially they're not making a 27 judge court. They're making 3 courts of 9 judges from a 27 panel. Given they think they can randomize it by however the appellate court system does, but no matter what, those judges each are going to have individual agendas, individual biases, individual religions, individual concepts of what we should be as Americans and how the Constitution is read. That's why we entrust these 9 specific people with this. We don't want 27 judges to have different sayings on essentially different courts. When you break that 27 panel up, you're getting 3 different courts. You're creating 3 separate Americas, essentially. When you have someone going to that court and there is a decision on there, that decision holds. That decision could have been completely different with any of the other 2 courts or any other random assortment of courts. We're not talking about the legitimacy of Ruth Bader Ginsburg or Anton Scalia. We're not talking about their legitimacy. We're talking about the legitimacy of the court itself. By putting that many people in the court, you're creating such dissent between the courts that there's no recovery. Because let's say if something goes up and you get a full conservative panel, that's going to be a judgment that's going to be a full conservative decision. And same with the other side, with liberalism. We are not going to have a certain way that they're going to be. They're not going to be perfectly balanced. There's no perfect balance in randomization. Anyone that knows math knows that. So that randomization is going to delegitimize the court itself, because there are going to be multiple courts. Going on to their term limits, the concept of a term limit really makes the branch operate in a completely different way than the other ones. They don't have to worry about election. They don't have to worry about, what my choices are going to be. They're not going to take that time, say, I only have 18 years to change this world. These justices, when they're appointed, it's a lifetime appointment. You essentially give them so much power by saying you are here for life, but it's balanced by by Congress and by the executive branch. That's what makes it so unique. We have these statuesque people that we trust with our rights. We trust with interpreting the Constitution. We want some people to be conservative. We want some people to want to change things. We want to see a living, breathing uh, uh, Supreme Court. Whereas if we have multiple courts being broken into these little variants and stuff, we're not going to have a Supreme Court. We're going to have Supreme Courts that are going to have different choices. So that's why we have to vote for the neg, because it's not simply a question of getting the backlog filled. It's a question of what is going through there. Like Kimberly said in the beginning, they're not through, there's no backlog due to a lack of justices. There's a backlog due to lack of evidence. And Sean even backed it up himself. He said that there's no reason that these people should be going to the Supreme Court unless they have their full evidence. Why are we going to let them essentially gamble it on a court that may be stacked against them? Why are we trying to unbalance our judicial system? Why are we trying to add a third leg to that little hanging thing that Lady Justice has? That's not going to be balanced. We need to make sure that we have a judicial system that supports the people and is backed by us, and they understand what we want. That's why we need to vote neg, and that's why we need to preserve our court system and preserve our land. Thank you.
Thank you very much. Christopher, I think you were referring to the scales of justice. That's what Lady Justice is holding on to.
Yes, those.
So there is no cross-examination at this point. That was the final negative speech. So to deliver the final affirmative speech in the debate, we have Mark Espinosa.
Good evening, and thank you for those who are joining us today. My name is Mark Espinosa, and I'm going to tell you why the affirmative is winning. The negative mentioned many things about the status quo. I'm here to tell you that the status quo is broken, and this is why we need to implement change today and implement this reform, because we're founding this from 1869. And according to Russell 18, in 1869, when the number 9 was chosen, the U.S. was roughly a tenth of its current size. Laws and government institutions were far smaller and less complex. This means that there wasn't a lot going on at the time, and we've evolved from then and now. I once again say the status quo is broken, and this is why we need to make change for the 27th justice. You heard Sean and Ariella mention the many, many things that are deficient with having the 9th Supreme Court justice. And let me tell you some of the deficiencies that come along with that. You heard Sean and Ariella speak about the 80 out of 8,000 cases that are only being heard per that term. That is unconstitutional, and that is discriminatory. If we had more Supreme Court justice, that would be implemented to seeking higher justice for those that are seeking justice. The reason for people going to the Supreme Court is because they've been already to the lower level to now go to the higher level to seek justice at the Supreme Court level. And if justice isn't being met at the Supreme Court level, then that is unjust. And that is because the status quo is broken. You've heard my team talk about the court backlog and the clog. The clog, let me give you an example, is like a roadblock in the road. And in order to get that roadblock out of the road, you have to physically move it. And that is what's the problem, is we're having a backlog of people not getting their cases heard because of the court clock. In addition, I would like to say that there's a lot of trial dates and errors that come along with this. And this is why you need to vote the affirmative team, because we are winning this. And that's all I have for tonight. Thank you guys for coming and watching this team debate. Thank you.
All right, thank you very much, Mark. And I appreciate everybody for doing this debate tonight. And I'm going to, there we go. So thank you all for watching our debate tonight. At this point during the debate, if we were meeting in person, we would have the audience be cheering, right? We would give our debaters a round of applause, and we would do that thing where I would say, if you think the affirmative one, let's hear you clap. And then if you think the negative one, let's hear you clap. And we would do that a couple of times to really get these debaters the loud round of applause that they deserve. This work is not easy. They make it look easy because they do such a good job, but a lot of research goes into this. This is not even our current typical debate topic. So they're doing additional research, practice, discussion. There's a lot that goes into putting this together, and also us trying to figure out how to do this on Zoom for you all. Added just that extra layer of nervousness and confusion. So what I would like to do is, most of our debate team is here tonight in this Zoom chat. So I'm going to change the view here, and I'm going to ask the debaters to, if you can briefly turn your cameras on and give your teammates a round of applause for their efforts tonight. Most of the folks who spoke tonight are in their first semester on the debate team or their second semester on the debate team. So this is not easy, and we should appreciate their efforts. So if you can all turn on your cameras briefly and just give them a little round of applause. We can also say hello to the other members of the debate team before I end the recording. So I will summarize. Thank you all again for watching our video, watching our public debate. We hope you enjoyed it. We hope you learned a little bit of something about this, and we hope that we gave you something to think about. What you can do is, if you want to vote, if you want to choose, if you think the affirmative won the debate, or if you think the negative won the debate, this video will be on YouTube, and I will leave the comments open so you can make a comment down below saying that you think the AF won or that you think the negative one. You might even engage in some discussion about why you think those things are true. Add a little bit of your thoughts to the research that we've done. This is by far not a complete debate. No one debate that is timed is ever the complete debate on an issue this complex. So we would look forward to your contributions to that. So thank you for joining us, and I hope you all enjoyed that.